Singapore recognizes that international cooperation is key and indeed an indispensable part of that fight. And in our own small way, Singapore has contributed to this international effort through the provision of mutual legal assistance and our active participation in various international legal forums. For instance, we routinely provide mutual legal assistance to assist other countries in investigating and prosecuting corruption, retrieval of documents and financial records, freezing of assets, enforcement of foreign confiscation orders, and other forms of permitted assistance. And I think some of you may have heard of the 1MDB case in Malaysia, and Singapore played a very key role in providing the assistance that Malaysia requested. And we have mutual legal assistance treaties with several jurisdictions, and I negotiate more such treaties. But besides bilateral treaties, we are also party to certain multilateral treaties, such as the ASEAN Treaty on Mutual Legal Assistance in Criminal Matters. But more importantly, and I stress this, even without a treaty, Singapore can and will provide mutual legal assistance based on mutuality. Many times I have visits from foreign counterparts, foreign government ministries asking us to negotiate and sign up a mutual legal assistance treaty because they need one desperately with us, and assure them, don't worry, even without the treaty in place, we will render help based on mutuality or reciprocity. We are also a signatory to certain United Nations conventions, and I wouldn't go into this in detail now in light of time. In addition, CPIB is an active member of various international forums tackling corruption, such as the International Association of Inter-Corruption Agencies and the International Anti-Corruption Coordination Center, which coordinates global law enforcement responses to allegations of grand corruption. Now, I would end with some closing remarks. There is a Chinese proverb, 上联不见相连为, which means that if the top bean is askew, the bottom bean supporting it will also be crooked. Or there is also another equivalent Malay saying, ikan busuk mulai dari kepala, which literally means fish rots from the head down. So ultimately, keeping a system clean must start at the very top. Those at the top will become role models and set the attitudes and expectations for the public servants and institutions under them. We must establish leaders who have a strong political will to eliminate corruption. So people of integrity must be continually appointed to run the system and enforce the laws. Over the years, through robust investigation and prosecution of corruption offenders, as well as constant education and reinforcement of our strong stance against corruption, Singapore has developed a society and culture that eschews corruption. Singaporeans have come to expect and demand a clean system, and Singaporeans readily report cases of corruption when they encounter them. The people themselves thus also help to keep the leaders in check, creating a virtuous cycle of cleanliness from corruption. However, since corruption is driven by human nature and greed, no one is immune from corruption, and we must not let our guard down against corruption. I'm therefore grateful to the organizers of this symposium, which brings together a stellar cast of eminent practitioners, regulators, and experts. It is only through learning from one another and working together that we stand a chance of tackling the scourge of corruption and transnational economic crime. I look forward to the many interesting sessions lined up for us at this symposium, and I wish everyone a very good and beneficial week ahead. Thank you.
Thank you, Lucian. I now call upon the Honorable Godfred Yeboah Dame, Minister of Justice and Attorney General of Ghana. Please welcome the Attorney General of Ghana.
Good morning, Symposium, the co-chairman of the Symposium, Professor at the Center of Development Studies, Professor Barry Ryder, my Lord Mayor, Your Excellencies, honorable members of the House of Commons. I am particularly delighted to speak to you on the first morning of this truly unique forum, the 39th Cambridge Symposium on Economic Crime. And my sincere thanks go to the University of Cambridge, particularly the founder, the co-chairman of the symposium, Professor Barry Ryder, for inviting me. I salute the extraordinary effort in sustaining this remarkable activity over the past 40 years. This is my second appearance here, the first in 2017, in my previous career as Deputy Attorney General and Deputy Minister for Justice of Ghana. I found the organization of the forum simply amazing at all my times. We're recording at least 2,000 participants from over 100 countries annually since 1982, and drawing leading personalities in law enforcement, politics, and government all over the world. The Cambridge Symposium on Economic Crime has provided a platform for analysis and examination of the never-ending and ever-evolving threats facing the global financial system as a result of criminal and other nefarious activity. And it is correct to say that the Cambridge Symposium has established itself as not just a talk shop, but has earned the enviable track record of being a global platform that delivers practical solutions to economically motivated crime and misconduct worldwide. The theme for this year's forum, Selling Status, Insider Crime and Abuse, addresses a very practical reality in the financial world today. As Ghana's Attorney General and Minister for Justice, I am constitutionally responsible for the initiation and conduct of all prosecutions of criminal offences in the Republic. I separate 10 agencies of state involved in the fight against economic crime and corruption, and collaborate with cabinet colleagues in this regard. Since the last time I was here, in 2017, Ghana has had its fair share of threats to the financial sector. There has been a banking sector crisis, which shook the foundations of the financial system in Ghana. Between August 2017 and January 2020, Ghana was hit by a severe banking crisis that affected several institutions, several indigenous banks, as a result of which the central bank ordered the takeover of some of the banks by another indigenous Ghanaian bank, the Ghana Commercial Bank. The central bank cited the insolvency of the banks in question as the major reason for the revocation of the operating licenses of the affected banks. In addition to the takeover of some of the banks, 5 indigenous banks were consolidated to form a new bank called the Consolidated Bank Ghana Limited. A deeper examination of the banking sector crisis that rocked the financial environment in Ghana showed that poor corporate governance, non-performing loans, breach of directors' fiduciary obligations, credit risk, and regulatory lapses were responsible for the vulnerabilities the banks were exposed to. Internal auditors, who were required to superintend proper accounting practices, became complicit in illicit practices and heavily immersed in cover-up for executive directors. The recent Ghanaian banking sector crisis held ramifications for the entire economy of Ghana. It was the most severe economic crisis to affect Ghana since its independence in 1957. The COVID-19 pandemic dealt a further devastating blow to the economy. The crisis was a vivid manifestation of the devastation that can be unleashed on the economy by a poorly regulated financial system. To deter a reoccurrence of the situation, 20 individuals and companies have been put on trial for offenses bordering on stealing, fraudulent breach of trust, money laundering, dishonestly receiving, and willfully causing financial loss to the state. Another phenomenon that afflicted the financial sector of Ghana between 2018 and 2020 was the emergence of many unlicensed entities operating illegally. The leaders of such entities often lived a lavish lifestyle on the proceeds of their illicit activities. Prominent among such entities was an amorphous organization operating a microfinance institution under the guise of, guess what, gold trading, and illegally using the name of a bank. It called itself Men's Bank. Apparently, Men's Gold, as it was also called, had been dealing the purchase and deposit of gold collectibles from the public and issuing contracts with guaranteed returns to clients without a license from the relevant authorities. Against caution from the central bank, tens of thousands of individuals got hooked onto the scheme devised by the company. Following the close down by the Security and Exchange Commission, the customers could not retrieve their funds. The company relied on the greed and ignorance of thousands of otherwise hardworking Ghanaians who were prepared to pay their life savings to the suspects in the case, resulting in losses worth millions of dollars. The situation caused misery and distress to many homes and unleashed a social crisis as riots and demonstrations broke out in the streets of Accra and other parts of the country. In real terms, people lost their homes, and some marriages have even broken up as a result of the men's gold saga. Indeed, one lawyer suggested that the story of men's gold could cause a civil war in Ghana in a manner akin to the civil war in Albania in 1997 caused by aggrieved customers of a Ponzi scheme. By the grace of God, Ghana was saved from such a situation as a result of the prompt action taken by authorities at the helm of the financial system. And I'm happy to state that after painstaking investigations, dockets on that financial crime are almost ready for prosecution to commence in earnest. The Office of the Attorney General is prosecuting other high-profile cases involving the office's offenses of willfully causing financial loss to the state, stealing, corruption, fraud, procurement breaches, and money laundering. These cases have as their sole object the principle of holding public officers to account and involve sums of over $850 million. The current government of Ghana recognizes that the most enduring way to fight corruption and protect the financial system is by strengthening the regime for doing so. In this regard, with a clear understanding that corruption thrives in an atmosphere conducive to its concealment, and that access to information is a vital tool in the fight against corruption, the government ensured the passage of the Right to Information Act 2019 at 989. Other bold legislations introduced by the government to curb official wrongdoing in the public sector are the Witness Protection Act 2018 at 975, Anti-Money Laundering Act 2020, the Corporate Restructuring and Insolvency Act 2020, the Companies Act 2019, Revenue Administration Amendment Act of 2020, State Interest and Governance Authority Act 2019, as well as the Real Estate Agency Act 2020. The new Companies Act in particular represented a giant step in the quest for sound corporate governance in Ghana. By virtue of a variety of measures introduced by the Companies Act to ensure the verification of information entered in the company's register, the duty to provide particulars of beneficial owners under the Act, amongst others, the recently established Office of Registrar of Companies has become a very legitimate partner of the government in its fight to stamp out corruption and financial indiscipline. Mr. Chairman, the complexity of modern-day economic crime has necessitated the introduction of more non-custodial sentences and, in appropriate cases, non-conviction-based punishment. As Attorney General, I have sought to introduce legislation which, if properly applied, can speed up the administration of justice and ease congestion in our court. A few weeks ago, Parliament enacted an amendment to the Criminal Procedure Act of Ghana to introduce plea bargaining into Ghana's criminal jurisprudence. To the extent that economic crimes are not exempted from an application of plea bargaining procedures, the nation stands to avoid long and costly trials which have no guarantee of compensation and restitution for victims of the offenses through a sound application of those procedures. I will conclude by suggesting that the multiple manifestations of economic crime show that there is no single structure under which wrongdoers operate. Wrongdoers exploit differences between countries to further their objectives, enriching their organizations, expanding their power, and avoiding detection or apprehension. They gain influence in government, politics, and commerce through corrupt and illegitimate means. The need for states to cooperate in combating the threat of economic crime is therefore more than imperative. In Africa, the launch of the African Continental Free Trade Area, whilst presenting Africa with its greatest opportunity to show to the world the strength of its potential and the entrepreneurial spirit of the people, has also unleashed a new set of concerns to law enforcement authorities. These take the form of migratory problems, social integration challenges, the good old phenomenon of corruption, money laundering, and environmental challenges. Economic crimes threaten the prosperity of nations and weaken public confidence in the government of every nation. They can not only undermine the values we hold dear as a society, but also prop up authoritarian regimes that wreak havoc in the world. We are acutely aware of the knock-on effect of corruption on human rights internationally and on our efforts to combat environmental damage. The punishment of corruption, therefore, requires the establishment of a fair, honest, and efficient justice system. The need to strengthen criminal justice must sit right at the top of our developmental agenda. Criminals ought to be deprived of their assets in order to reduce the impact of their actions and the inspirations they serve to others globally. Crime must not be rewarding. I wish you a very fruitful week as we listen to a rich insight of distinguished and accomplished speakers from around the world gathered here. Thank you very much.
And thank you very much. We'll have time for one other speaker before.